Thank you very much, and good evening, everyone. It's my pleasure to present Verité Research's research to this esteemed audience. This research, as you know, focuses on private sector corruption with um, I will present in this structure today. We'll first talk about the research approach. Second, the legal gap analysis on private sector corruption in Sri Lanka. And third, the recommendations, but I will only limit myself to a few recommendations. The objective of this research was to identify gaps in Sri Lanka's legal system vis-a-vis the UN Convention Against Corruption. Our anti-corruption law, as you know, that was passed in September 2021, now deals with the issue of private sector corruption. So it deals with private to public sector corruption and private to private corruption, specifically in the form of bribery. And then it goes on to deal with certain other offenses that relate to the private sector as well. So here we are using the UN Convention Against Corruption as a framework and assessing Sri Lanka's current law post 2023 against that framework. So our research approach, as I said, is pinned on the UN Convention Against Corruption. So we first look at direct mentions of the private sector in the UNCAC. Second, we look at the areas that are most relevant to the private sector, such as preventative measures, bribery, liability of legal persons, whistleblower protection, and embezzlement, campaign financing, and asset declarations. And then we also look at the UN Convention Against Corruption review mechanisms for Sri Lanka in the years 2013 and 2017, because as you might be aware, the UN Convention Against Corruption assesses through parallel states parties, it assesses each state party's compliance vis-a-vis the UNCAC. So first they looked at chapter 1 and 4 of the UNCAC, and the second round of assessment looked at chapter 2 and 5 of the UNCAC. So we've looked at their feedback as well. These are the laws that we assessed in Sri Lanka against the UN Convention Against Corruption. As you know, the Anti-Corruption Act, the Companies Act, Accounting Standards and Audits Act, and the list goes on, all the way up to the Regulation of Election Expenditure Act in Sri Lanka. These contain a spate of recent laws that really focus on anti-corruption as well. So we have identified then the areas with gaps and areas with no gaps. And when we say no gaps, what we mean is that there are no gaps when we compare it to the UN Convention Against Corruption. Now, the UN Convention Against Corruption is not necessarily the gold standard, but we have used this framework because that is what Sri Lanka's Anti-Corruption Act has tried to aspire to. And if you see recently in the IMF's priority recommendations for Sri Lanka as well, they have focused on different laws actually complying with Sri Lanka's obligations with the UN Convention Against Corruption. So that's why we thought it would be a useful framework to use, but in recommendations that relate to best practices in the forthcoming report, we will talk about how there are best practices that actually go beyond the requirements of the UN Conventions Against Corruption. So saying that there are no gaps doesn't mean that we don't have gaps in whistleblower protection in Sri Lanka vis-a-vis best practices in whistleblower protection or campaign financing or asset declarations. So we have identified these 4 areas: preventative measures, bribery, liability of legal entities, and trading influence, as being areas that contain gaps. And then we have also recognized one cross-thematic gap that I will get into now. So in the UN Convention Against Corruption, all the obligations that are set on the private sector refer to the private sector in general, and it does not proceed to define what the private sector is. It only mentions the private sector. But in Sri Lanka's Anti-Corruption Act, we have defined this to mean only specified business enterprises, as defined under the Accounting and Auditing Standards Act. Now, as of 31st December 2023, this only applied to 1,707 companies in Sri Lanka. So this is a concern that applies across all the gaps, because even where we have found the Sri Lanka's law to be compliant with the UNCAC, that still means that it is only compliant with respect to these companies. So that remains a huge gap, and we'll make recommendations on this. So the first gap on preventative measures, which is pinned to Article 12 of UNCAC. So these are the requirements under the UNCAC. So it first talks about, I will only highlight the important bits. It talks about identifying the legal and natural persons involved in the establishment and management of corporate entities, what we refer to as beneficial owners, in addition to the general management of a company. And then it talks about prevention of conflicts of interest. And it also goes on to set a requirement on taking measures about off the book accounts. Now you can see here the obligation is about criminalizing the making of off the book accounts. So then now I will come to Sri Lanka's law. Sri Lanka's law doesn't have provisions regulating ownership transparency. So it doesn't require comprehensive disclosure of beneficial ownership to the authorities, and there is no legal requirement to make beneficial ownership publicly available. So this remains a big gap that has also been talked about, and that also forms one of the priority recommendations of the IMF Governance Diagnostic Assessment. It has recommended that Sri Lanka set up a publicly accessible beneficial ownership register, which had been gazetted and placed on the order paper of Parliament. There was an amendment to the Companies Act that was placed on the order paper of Parliament prior to the elections. However, that still doesn't go far enough in terms of public accessibility. The draft law as it stood didn't go far enough in terms of public accessibility to beneficial ownership information. The second point on conflicts of interest is specific on public to private sector employment, people moving from the public sector into the private sector. So Sri Lanka does have certain specific areas like related to the central bank and other specific sectors, certain commissions, where it might prohibit you from entering the private sector or being hired by the private sector post leaving a public sector office. However, it doesn't have general provision related to all public sector employees. Now, I go on to the next gap, that is about preventing the manipulation of books and records. So the Companies Act talks about the maintenance of accurate records, but it doesn't go so far as to forbid the maintaining of the books records, where a lot of the problem around corruption obviously lies. Then we go to the point about liability of legal persons. And here, the UNCAC requires that there should be liability of legal persons, and the liability can be criminal, civil, or administrative, and it does not affect or replace the criminal liability of the natural individuals, the natural persons. Now, if you look at the anti-corruption law and section 116, it talks about how if a corporate entity is convicted of a bribe, it is the directors, agents, and officers that are liable to fine or imprisonment. And this is a good thing. There are lots of countries where corporate liability is only placed on the corporate entity and not on the natural persons. So Sri Lanka's law has solved that problem, but in the process has left out the corporate entity itself, so that we identify as a gap. And then in terms of penalties being imposed on corporate entities if they were to be so, what's envisaged right now is a maximum fine, which is at 1 million rupees, and there is no provision for non-monetary sanctions such as debarment, from dealing with the state. This exists in other pieces of law, but not in the Anti-Corruption Act, and not comprehensively. Then we go to the section on bribery. Now here there is an interesting disconnect between this is the UNCAC provision. So it talks about criminalizing the promise, offering, or giving of a bribe, as well as the solicitation or acceptance of a bribe. But when we come to Sri Lanka's law, for soliciting or accepting directly or indirectly an advantage, bribery in the private sector only imposes liability on the individuals, but not on the corporate. Whereas for the giving or offering of a bribe, it does impose liability on the corporates. Then this is another point based on best practice and the UNCAC. We talked about the UK Bribery Act and the Foreign Corrupt Practices Act in the panel during the panel discussion. In those countries, you place a positive obligation on the private sector to take action to prevent bribery, and there is an offense of failing to prevent bribery. However, in Sri Lanka's law, because we didn't go too much into the law, what we've talked about, what is proposed, is that when you're accused of a crime of offering a bribe, then you can take the defense that you have taken all due diligence measures. But there is still no positive obligation or a positive offense cast on the private sector. Then we go on to Article 18 about trading in influence. This is the obligation under the UNCAC, the UN Convention Against Corruption. So the promise or offering or giving to a public official or any other person, directly or indirectly, of an undue advantage is what is talked about in the UN Convention Against Corruption in the context of the offense of undue influence. But in Sri Lanka's Anti-Corruption Act, we have missed out on talking about this undue advantage. So it talks about the giving or the doing of an act that they can do anyway, right? It doesn't refer to then being a trade-off of an undue advantage or abuse of power. So it leaves those out, and in fact the language seems to almost be a mistake, because in the provision around trading in influence, it has the language and then says shall be guilty of the offense of bribery, not of the offense of trading in influence. So these are things that require fixing going forward. All right, I'll quickly zip through the recommendations. We have classified the recommendations into two categories: ones that are covered inadequately by the domestic law and ones that are not covered by domestic law. So I go into 4 recommendations in total. On the ones that are inadequately covered, one is obviously the limited legal liability. So this is the cross-thematic gap that we talked about. So in order to capture the entire formal sector in Sri Lanka, a recommendation that we make is that we capture those companies that are required to pay EPF, ETF. So thereby we can be more in consonance with the state's obligations in terms of the UN Convention Against Corruption. And then we go to the gaps that are not covered by the domestic law. So no laws regulating ownership transparency. We obviously need beneficial ownership information to be disclosed to the public and being made publicly available, but of course to the authorities as well, more comprehensively. And then on conflicts of interest, it's the same thing, that you need to introduce provisions. It can be that you introduce cooling off periods and restrict the public officials themselves, or you prohibit the private sector from hiring public officials. You can take either route. And then on off-the-books accounts as well, that you need to criminalize the maintenance of the off-the-books accounts by introducing a books and records offense. Thank you very much. I tried to keep that brief. Thank you.